A warm welcome to all my panelists and participants for today's webinar on Consumer Protection Act. As most of you attending this would know that this is an act recently passed by the Parliament and would come into force shortly. So most of us do not have the complete knowledge on what this is going to be and what it would do to our businesses. So people from different aspects of the advertising industry would want to know as to how do we go about. We've got an expert, a crack panel today, who would take us through every aspect of this. We have eminent lawyers with us who would break down the act for us. We have people from the creative side who would see and tell us as to whether creativity would be heard. We have someone from the legal side of a consumer of a product itself, someone from HUL who will give us the client's perspective. And we have someone from ASCII as well. ASCII has been tracking this for a long time during all my past 33 years of media as one of the from the media owner's side. We dealt very extensively with ASCII, and at every point of time, they kept on guiding us as to the guidelines of various kind of advertising we used to. And my background is that I have spent a lot of time in print, both with the Indian Express and Midday and Network 18, so Short Indian Network 18 as well. And at every point of time, the moment we got complaints, ASCII used to write to us, and we used to take corrective measure as in when was required. Now, the current act itself, we are really unclear as to who is going to be the guiding force, who is going to decide as to whether a particular ad is offensive in nature or needs to be taken down. So to understand all this, I think this panel would be of a great help, and we'll all go back in a better with a better understanding that we have today. Before I hand this over to the chairman of our legal and IPR committee, Mr. Bharat Vasani, I'll just take a minute to talk about the chamber. The Bombay Chamber of Commerce and Industry, as most of you attending would know, is a 184-year-old chamber, the first chamber set up in India by the Britishers at that point of time. Over the years, the chamber has taken up every single issue which pertains to the corporate, helps decipher every single act and law which is passed by both the state government, the central government, some of the regulatory authorities, and for the benefit of its members. At the same time, it takes feedback from the members and takes it back to these authorities, telling them about the concerns, if any, from any of these. The chamber in recent times have a very, very thriving mediation cell, a labor advisory cell, an arbitration cell, which is helping corporates resolve some of their issues within themselves rather than spend a lot of time in courts. So without taking much time, I would hand this over to Bharat Bhai. A small request that all of you all make it as interactive as possible. Please post your questions in the question and answer section. And at the end of the webinar, Suhas will take this, our moderator, Mr. Suhas Tuljapurkar, would take this up at the end of this, end of the webinar, sorry. So over to Bharat Bhai. Bharat Bhai.
Thank you, Sandeep, and very good afternoon to all of you. And unfortunately, I may have to eject myself out for taking some urgent call, but I would love to listen to this panel on this new subject. I would say why I'm calling it new subject, because the Consumer Protection Act 1986 was always there, but this new legislation, which was finally made effective from 20th July, it was passed by Parliament last year, but it got effective from 20th July, has several new aspects and features which were not there in the 1986 Act. And that's why many call this legislation as a kind of a game changer from the consumer's point of view. And it has certainly tilted the balance in favor of the consumer, because completely new provisions relating to e-commerce, product liability, class action lawsuits, unfair contracts, celebrity endorsement, these were not even there as a part of the Consumer Protection Act 1986, have come into the statute book now. But I think the act really catapulted into a limelight and became a center for discussions in not only legal circles but elsewhere also, as within 3 days of the act coming into force, the Ministry of Food and Civil Supplies, the Ministry of Consumer Affairs notified the E-commerce rules 2020 on 23rd July. And these e-commerce rules which have been notified, which are, first of all, as you know that except for the mention in the FDI policy, e-commerce was not part of any statute. In fact, as if they were existing without any sanction of law, the way e-commerce function. And despite the fact that Amazon and Flipkart have become such a popular with middle class in India, but there was no law which if officially kind of blessed them that they exist in the eyes of law. So these are the e-commerce rules which are framed under section 94 of this act, which has kind of created quite an upheaval in e-commerce platform, and not only e-commerce platform, but even the media, OTT platforms like Netflix and Amazon are also worried about the implications of this act. And when this panel discusses in detail, I would like to ask some of the questions also. But one thing which is very, very interesting is that there are several lawyers, and I've interacted with quite a few of them, are debating even the constitutional validity of these e-commerce rules. And this constitutional validity may be assailed before either the Bombay High Court or the Supreme Court on three specific counts. Number one, legislative competence of the union government, which is the central government to legislate on a matter which some argue will lead to the state list and not the central list. Number two, extraterritorial part, because the e-commerce rules, and I would like to deal with some aspects of the e-commerce rules very briefly, but the e-commerce rules are specifically made applicable to digital products and entities outside India, so long as incorporate entities not located in India, having no place of business in India, but they are systematically targeting Indian customers. Then in that case, the products and services to be made available to Indian customers. Then also they are subject to comply with the provisions of these rules, including appointment of the nodal officer and all that stuff. So many people are wondering that why the hell I have nothing in India, I'm selling it from here. But they made it very clear, digital products and products sold by entities outside India. So extraterritorial part is under Article 245, which will be examined by the courts. And the third limb, which is likely to be challenged, are the rules which are made under Section 94 of the Act, hence I read with 101, are they ultra vires the Act? Cardinal principle of Indian law is that the rules are meant for procedural details, which form has to be filled up, how much fee has to be paid, while these e-commerce rules lay down very substantive legal principles and it creates rights and liabilities legally. Now, should it have been part of the statute? Statute has only one small section 94, which essentially says for preventing unfair practices in the e-commerce space, the government can take such measures. I'm not reading the exact section 94, but broadly in this fashion. And the way government has gone about prescribing in great detail what all an e-commerce entity is supposed to do, there are people who believing that this is a classic case of excessive delegation, and which Indian law does not permit. Then if they wanted to regulate e-commerce entities through rule-making power, they should have as well provided a substantive provisions in the Act. 94 and 101 does not give adequate powers to the central government to make such elaborate rules for e-commerce entities. Now, on the extraterritorial part, I am of the view that perhaps the courts may uphold the extraterritorial part, because ultimately this is whatever entities, the objective is to protect consumers in India, and so long as they are targeting consumers in India, the government would argue before the Supreme Court that, well, the nexus theory laid down in the several landmark cases under Article 245 of the Constitution, which lays down that Indian Parliament has a power to legislate extraterritorially. The Article 245 of the Constitution categorically empowers Indian Parliament to legislate for outside India, so long as there is a sufficient nexus with India. And there is this constitution-based judgment of 2011 in GVK Industries versus Income Tax Officer, which was just late Justice Sarosh Kapadia, who was then the Chief Justice of India, has passed a landmark judgment that it should be a real nexus. It would not be something superficial stuff. So if there's a real nexus with India, then the Indian Parliament can legislate for subjects and matters which are outside India. So I think extraterritorial part, perhaps there's a weak argument, because ultimately Government of India lawyer will get up in the court and say, sorry, I am legislating for my consumers in India, and so if they are targeting Indian consumers, I have every right to legislate. on the issue of legislative competence of the parliament to legislate on a subject matter which is reserved for the state list, I think even that is also a bit of a weak argument, because of the fact that while I do agree that trade and commerce is falling under the state list. But today when we are looking at the situation in 2020, Constitution was drafted in 1949. And the founding fathers at that time have not even used the word like e-commerce or consumer protection as a part of various entries in the 7th schedule. So essentially the government of India is deriving the power under the residual entry 97 of the list 1 and says that I have the power to legislate. And also there are certain provisions like Article 301 and 302 of the Constitution which empowers government to put restrictions on interstate trade of commerce and everything. So my view is that the Attorney General and Solicitor General of India will perhaps deal with this argument that central government has power to legislate on e-commerce. The only weak area which I see where there's a chances of success are that the Section 94 does not give adequate power to the central government to legislate on matters. And they are not certainly procedural matters. What is prescribed in the e-commerce rule is very substantive, and I'm sure my friend Suhas, Tuljapurkar and others, experts sitting here, will deal in great detail. But very substantive provisions of the law are now articulated in the form of rules. The government will try to argue that rules will be laid before the parliament as per the procedure and all that. If they have a problem, they'll point out. But that's not enough. The courts will see whether what enabling legislation, which is Section 94 and 101, does it give adequate legislative guidance to the government to legislate on the way government has gone about? If I start speaking on e-commerce rules, I will take away another 1 hour, so I don't want to do that. Let the experts who have come here debate on it. But so this is one area where I see a potential challenge to the constitutional validity of e-commerce rules. Now, there are a lot of gray areas in the e-commerce rules, as you all of must will. And I think most of the people never got adequate time to digest it because the rules were suddenly notified on 23rd July. And many of the people are now still digesting many of the e-commerce platforms. There's also a lot of concern in the media and entertainment space because of 2 reasons. One is that they have covered the digital platforms like Netflix, Amazon, Hotstar, and there are 24 such platforms in India. They have covered services being offered by them as part of the e-commerce rules. And secondly, celebrity endorsement. You have seen Amitabh Bachchan advertising from Rupa underwear banyan to every conceivable product and every conceivable services. So are all the leading stars now. You see Shah Rukh Khan all the time in Byju's ad. Now the liability is also sought to be fastened on the celebrity which is endorsing a particular product or service if the product or service is not meeting that kind of features which they are claiming. Now, these celebrities, and I head the media and entertainment practice at the law firm Cyril, Amarchand, where I work as a partner. Many of the celebrities are now rushing to us that, this contract has come, but tell me, how do I take any major liability? If suppose the product turns out to be deficient, I have never used this product. So I'm just a celebrity who's endorsing the product. Am I supposed to do a due diligence? And what kind of capabilities I have to find out whether this particular product has the features which it is claiming? And tomorrow, if there's a claim against me, whether the insurance company will give me insurance policy against such claim. So the celebrity endorsement part has also created a lot of kind of upheaval and anxiety in the minds of various celebrities which have been left, right, and center, endorsing various products and services. So this is a very comprehensive legislation. In fact, the time allotted may not be adequate to go in detail, but we have people from Hindustan, Unilever and others, experts who will be able to bring in a very practical perspective of some of the challenges which this new legislation will bring about. They are also planning to set up this Consumer Protection Authority as a kind of in-house mechanism too. There was no regular such authority in the previous act, so now they created that new authority. But let's see how efficient that authority is going to become, and will it lead to any kind of conflict with the current mechanism of Advertising Standards Council of India, whether their functions are being taken over by this Consumer Protection Authority. So these are all the issues. As we are too early in the day. I think many issues are still very unclear even to lawyers like us on this aspect. And I would expect, I'm sure the experts today who are invited on this panel will discuss in threadbare so all these issues which have come up because, and particularly the e-commerce rules, because the gamut is too wide. So I would now request the panelists to take over. I'll excuse myself for about a half an hour because of an urgent meeting I have to attend, a virtual meeting, but I will join again, and I look forward to very fruitful discussion on this entire issue, which is very, very relevant to all of us. Thank you.
Thank you, Bharat Bhai. Thanks a lot. May I now hand this over to our moderator for the evening, Mr. Suhas, Tuljapurkar. Suhas, will you take it over from here?
Sure, Sandeep ji, thank you. Thank you very much, Bharat, for laying down the foundation today for a very interesting panel that we have here today. I must say that, while Bharat has laid out a very, very broad agenda, I don't know whether we will ever be able to come up to his expectation in terms of coverage, not because of paucity of time, but also because of the fact that we probably do not have the exposure that Bharat has in the field and in these areas. But thanks a lot, Bharat, for that introduction and laying down the foundation. You see, before I would like to go across and start the panel discussion, I would like to do two things. I would like to, as a typical lawyer, say and put some disclaimers on the table today, put some caveats on the table today. Whatever we are going to discuss, it's not a legal opinion. It's not a final view of a lawyer. Please don't base your decisions on the discussions that we would be conducting and carrying on today. Secondly, we've also seen, and Bharat alluded to it to say that, sorry. Okay, thank you.
Please go ahead.
Okay, thank you. The second aspect is, we've already seen about 6 corrigendum being issued to the Consumer Protection Act in matter of no time. This act was drafted and put across to the Parliament about a year ago. It was approved. It just languished. It's been enforced since about June, and within no time we've had 6 corrigendums being issued. So there were 6 mistakes on the face of the found out and corrected. So we know the situation is a bit dynamic. What we may probably be discussing, may be turned upside down tomorrow because some clarification might come.
Sorry, Subhash, I think somebody's mic is on. May I request everyone to please put off their mics because there's some disturbance which is coming. Thank you.
Hello. Is this better now?
Much better. Please go ahead.
Yeah, thank you. So there have been 6 corrigendums that have been issued. There will be some more corrections that will come up. Therefore, I think the situation is slightly hazy, or it's dynamic. I mean, let me put it positively. It's a dynamic situation. Therefore, what we may be discussing today based on some of the elements of the law, may not hold true tomorrow. I think I must put that caveat. So these are some of the caveats and disclaimers. The second major thing which I want to kind of do at the beginning of this panel discussion is actually say thank you to all those frontliners who are fighting on COVID front. We've had healthcare experts, we've had doctors, we've had law enforcement agencies. The curve that we looked at the beginning of the lockdown is no longer a curve with numbers and lines. It has names attached to it now because we've started realizing somebody known to you is no longer there and is afflicted by COVID-19 or has gone into ICU. But despite of all these challenges, I think past 6 months, the COVID warriors, the COVID frontliners, law enforcement agency people, whether it is healthcare in the hospitals, whether it is just the sweepers at the municipal corporation, housekeeping agents all across, I think I have to, on behalf of Legasis and on behalf of Bombay Chamber, express a gratitude and a big thank you to all those people who have actually made sure that we are able to deliver this webinar and we are able to actually do something worth its while during this lockdown period. Thank you very much. Having said that, and having put the caveats aside now and having expressed my gratitude, I'm going to touch base upon what Bharat said as a very new enactment, with Consumer Protection Act 2019, which has become effective from June 2020. You see, what this act does is, I think this act actually puts consumer at the center of the economy. You see, we've had and we've known in India that each and every enactment, whenever a new enactment came in, we initially used to discuss whether this is old wine in new bottle. We used to also say, is this really a new enactment? I mean, it just changes the color of what was existing. Then there are certain enactments which are game changers. They actually change the game, the way in which you do business and you conduct business. There are some which are pivotal in nature, some enactments which are pivotal in nature, which actually pivot a particular industry to a very, very different level. And there are some enactments such as the Companies Act 2013, which are access tilters. They actually kind of change the complete, and they change your universe, and they tilt it in such a manner that you start learning, doing new things with new ways. I think Consumer Protection Act, the jury is out there, and I'm not the expert. Jury is out there as to what consumer economy. In my view, and having looked at this space since 1985, 86 onwards, I'm of the view that for the first time, the consumer rights are recognized in the statute today. And that statutory recognition of all consumer rights, except probably one, which is the right to a clean environment, which is not finding place in the enactment, but rest everything is finding place and is recognized as a consumer right. That's the fulcrum of this enactment. Having said that, we are going to focus today on the topic, which is media and entertainment, and basically misleading advertisements around that, more particularly focused on misleading advertisements. And has anything changed? Is there anything which is going to kind of drastically change the way we look at advertisements, or how you look at misleading advertisements? There are new draft guidelines that have been floated around by the government. The suggestions and objections have been called from all the stakeholders. ASCI has been mentioned there as one of the agencies which probably is a complementary agency to the new consumer authority, the Central Consumer Protection Authority. CCPA has been notified. There is a very senior IAS officer who has been designated as the authority. Their DG, etc., are being notified and getting delegated. That's the space today. And I'm going to start, we're really lucky and fortunate to have such a stellar panel here. We have Aazmeen, we have Ashwani, Raj, and Subhash. Just on a lighter side, Aazmeen would mean probably a guiding star, and I'm going to start with her. In terms of your opening comments on the Consumer Protection Act, focused around misleading advertisements, endorsement, and that space. Thank you very much, everyone. Thanks a lot. Aazmeen, will you please start with your opening comments?
Thank you, Suhas, and it's a pleasure to be here today. As opening comments on the Act, I'd say indeed it is a game changer. The reason being that we've always had a Consumer Protection Act from 1986, and that act was silent insofar as misleading ads, celebrity endorsements, or endorsements per se are concerned. So from a consumer's point of view, where they rely a lot on advertising per se to form their opinions and base their decisions on purchases of goods or services, this act now takes care not only of members who were in the past determining and deciding to actually self-regulate themselves through the ASCI Code of Conduct, but advertisers across the country today are governed by an enactment which will ensure that consumers are put in the front. So whether it is endorsers who can be celebrities as individuals, or it can be institutions or firms, all are now governed by the protection of this act insofar as consumers are concerned. And they have a moral responsibility to ensure that there is no misleading communication going out to a consumer, whether by omission, exaggeration, or implication. So from a consumer perspective, it looks very clear to me that clearly their rights have been enhanced by virtue of this enactment. Also, the fact that the district forum, the pecuniary jurisdiction has been enhanced. So today, a consumer sitting out of a small part of India gets the protection of being able to file his or her complaint before a district forum. In the past, that was not the case. So if you had a complaint on a product or service which was up to 1 crore, today you can go before a district forum, which is within your area of convenience, to file a complaint. And from that perspective, again, it makes life easier from a consumer's point of view. Of course, there are pluses and minuses to everything that we know in so far as this enactment is concerned also, which has taken effect from July 20th, it's no different. And from an advertiser's perspective, it puts in a lot of added responsibility. It's also a bit of a difficult one, because if somebody from a remote part of India actually files a complaint against an advertisement on grounds of it being misleading, and the district forum takes a view one way or the other, and then there is another person filing a complaint in another part of India and the district forum takes a view the other way around, it's a bit of a challenge from the advertiser's perspective on the media. Another interesting part of this is also, of course, that, gone are the days when e-commerce portals could actually say that, well, we're not the manufacturers of goods and services, so we are not liable for products which are sold on our platforms. Today, they become equally liable as the Act covers even their role insofar as consumers are concerned. So from a consumer perspective, it widens the horizon for justice in a very big way, to my mind.
Thank you. Thank you very much, Aazmeen, for that guiding kind of light there. From a star, I'm going to move to a nakshatra. Ashwani ji, will you kind of give your opening comments to all of us?
Sure. Thanks, Suhas, and thanks, Aazmeen, for setting the context here. I think she was right in what she just mentioned, that has actually changed the whole horizon here in terms of advertisement. Let me put it that way. If you look at advertisement per se has currently been regulated, it's not like that there's no regulation per se. There are a number of acts which are currently there which does talks about what advertisement can do, what it cannot. For example, if I may just mention one of them. So drugs and that Magic Remedy Act does talk about what can be done on advertisement, what cannot be. And likewise, if you look at sectorial regulators like FSAI, they also have a misleading advertisement definition very clearly being called out in the Act itself. And of course, a couple of years back, they also came out with a whole lot of a regulation itself on advertisement claims, etc., which one can make in the food industry space. So that's been there as such, which has been going on, and it has been done in different parts by different regulators, by different industries, and there was no one set regulator which would have taken care of everything. Now, what has been done is that in this act, when they brought out a key regulator, which is a key change in the regulation itself by bringing in a central authority, which becomes a key regulator for the advertisement. I mean, that's a key change which has been made here, and the regulator has been made responsible to look at number of elements. If you look at the rule, they actually are responsible to look at the consumer rights, unfair trade practice, your misleading claims, false and misleading claims, and of course the rights and enforcement of rights for consumer in a larger horizon. So that was a key scope which they have been looking at. Now, if you look at from an industry perspective, we have been following, all the law of the land, and also we have been following the ASCII code. Now, ASCII has been there for the last 35 years. Of course, Mr. Subhash is there, is going to talk about the contribution of ASCII. That's a code which we have been following as an industry, and it's quite holistic as such. And in a way, we fully comply. Most of the legal positions are fully embedded in the code itself. Now, that's been there and the code has been something been followed, and as a member and a non-member, we become binding and non-binding to a certain extent. But that being said, now if you look at now the new act, which what brings on the table is that it becomes really, really strict, because if you look at the overall framework of the law, it has the authority sitting centrally there, and the complaint can be made to the central authority as well as to the collector officers. So if you look at the overall framework, one is the regulator, which is the central authority we just spoke about, and then there's a investigating wing, as is the case in the competition law. The DG has the power to investigate. Likewise, if you file a complaint parallelly in before the collector, they will investigate and give the report back to the CA. So if you look at the number of places where the complaint can be filed against one advertisement, and really, really increase substantially. And the way how the investigation can be done, the powers are huge. For the purpose of investigation, you have a power to seize, you have power to investigate and enter into premises. So that kind of huge powers have been given there to the investigators when they are investigating complaint for misleading one. And it's not limited to the consumer who can file a complaint. Any person can file a complaint if they feel that this is a misleading complaint, misleading advertisement which has been broadcasted. And the onus is not only on the manufacturer, it is also on the broadcasting agencies who are actually broadcasting the advertisement per se, and also on the agencies and the endorsers. So of course, SK just talks about celebrities' obligation to do a due diligence. But in this case, they have brought on the concept of endorser without basically differentiating between a normal influencer or maybe a blogger with a celebrity per se. So that distinction has not been covered in the act which has been proposed right now, and that's going to be a little challenging the way we handle it currently. But on an initial note, I think it's a huge progressive step which a government has taken in this regard, and we have been quite supportive in terms of implementation of the act. And as Suhas, you just mentioned about the new draft regulation which has come in, we are working along with industries to put in our comments and see wherein we can factor in our concerns and how it can be addressed. So there we are, Suhas. So that's about it.
Thank you very much, Ashwani, and thanks for kind of actually laying down and scaring people that anybody can go to even a district collector to make a complaint. Right from there, as to whether you're a consumer or not, you still have a right and you can make a complaint. So I think it's a very broad spectrum. And you mentioned about Drugs and Magic Remedies Objectionable Advertisement Act, and I think I remember the first at the initial stage, very early in 1984 onwards, when the MRTP Act came, we used the Magic Remedies Objectionable Advertisements Act to hit out at Sherry Louis campaign that said you have a rap and you can reduce your weight. You see, from there onwards, I think we've moved, and I think we've predominantly moved because one, I think a far more responsible advertisement sector emerged in India, and therefore I'm going to kind of look out for Raj first and then Subhash in terms of understanding the new law now. What does it do to advertisement sector? What does it do to media and advertisement, if you were to put it that way? And does the industry look anything changing? Because we've had a perspective from Aazmeen, who is an outside lawyer, practicing lawyer. We've had in-house lawyer and a manufacturer representing through Ashwani. From the ad agency perspective, Raj, what are your opening thoughts?
See, as far as I'm concerned, honestly, while obviously it's a stellar action on the part of the powers that be introducing the new act with the intent of empowering the consumer and so on, there's absolutely no doubt in that front that it's putting the power in the hands of the consumer in the case of them having a problem with a particular product or service that they have sort of engaged with post having seen the communication piece. But the fact of the matter is that thanks to ASCII having been around as long as it has, agencies of any worth have consistently towed the line when it comes to putting out communication. They've been extremely responsible in this matter, and the guidelines have been exceedingly clear across categories, right? And whenever somebody's wrist has been slapped, obviously either the creative has been removed en masse from the airwaves, or whatever correction needed to be done has been made, and then the corrected piece of creative has gone out. So it's something that from a agency standpoint, there's undoubtedly a certain sort of thought process and system that has been followed for decades now, right? Does the new act coming in change things drastically? Well, if somebody from Raebareli decides that haven't got 50 women following me after I've sprayed Axe, but that is the way it was depicted in the ad, and therefore that's a letdown personally for me. So we have to be clear about what we entertain and what we don't, you see, very, very clearly. There is a dramatization that one will always do, which is absolutely, how would I put it, licensed is the way I will say. There is a dramatization that we will always do, that we will continue to do. And if any agency stops doing that, I would say that's their failing, right? Because you will always try to be ultra creative in the way you present your message. So in that sense, even if such a complaint does come forward that such and such person has not received the kind of response post having sprayed that deodorant, I just mentioned Axe as a passing sort of name. But I think then it is for the past that we to determine what is a true claim and what is obviously not a true claim, and what needs to be entertained and what does not need to be entertained, right? So it's all very well putting the power in the hands of the consumer, but you also have to discern. You also have to be able to decipher what you entertain and what you don't. This goes without saying. I think the other thing that, so I'm just going to add to what Aazmeen was saying, the fact that when you can make, at district levels, you're making observations about, about pieces of communication that are going out. I think that might end up in a deluge also, which at some, as in of, it's a possibility, right? I'm not saying it's a probability or it'll definitely happen, but it's definitely a possibility. So then, will the people who are behind the act be equipped to deal with this said deluge? And will they be, how do I put it? Will they be knowledgeable enough to sort of deal with it? Because ASCII has always been, right? Because it has constituted of members from the industry, from agencies, as well as from advertisers themselves. And if you recall, we were talking about this, the fact that it has operated almost like a B2B sort of body. The knowledge that ASCII possesses has always worked out well. Will the people behind, will collectors be able to tell, no disrespect to collectors, they have, I mean, they have tremendous responsibilities, but are they going to really, is this the bit that they are going to worry about when it comes to a piece of communication, or do they have much larger fish to fry, and therefore should somebody be appointed specifically who's an expert in this matter, like a subcommittee or an offshoot of ASCII, whatever the case may be? That's something that needs to be thought through.
No, thanks a lot. Thank you very much, Raj, for those, are we equipped to deal with the deluge question? And I mean, frankly, the question that comes to my mind is, as a country, as a society, as a jurisdiction, are we matured enough to understand these issues in the same manner as a far more evolved society would probably look at these issues? But that's a larger question. I'm not going to deal with it today. But you've raised a very, very clear kind of issues which are very core to implementation. Frankly, my reading of the law is that a declaration about an advertisement, whether it is misleading or not, is left to the CCPA predominantly. You see, therefore, I would fight it out if a case comes to say that no, district court is exercising its jurisdiction to declare it to be a misleading advertisement. I would fight that tooth and nail, because as I see, the declaration as to an advertisement is misleading is predominantly left to CCPA. Of course, the appeal from CCPA would go to National Commission and thereafter will go to the Supreme Court. Having said that, I'm not holding out today for that premise. A second issue is that, you talked about, the dramatization, and I will come back to in the next round after we've spoken to Subhash, in terms of understanding what does this law does to that, exaggeration, dramatization, that representation. Subhash, it's very important that we hear you on your initial opening remarks, because you are representing today, everybody in the industry. You yourself a consumer. As I said, each one of us is a consumer, and therefore we are stakeholders. And as ASCII, I think you represent every other stakeholder that's there talking about misleading advertisement, whether it's advertiser, whether it is agency, whether it's media. Subhash, your opening comments, please.
Personally, I feel it's a very good thing. You all have used words like game changer, putting consumer at the heart of industry, etc. All of it is valid. I think it's a very good thing the CCPA has been formed. And I say this simply because when I look at the objectives of the CCPA, they are very much aligned with what ASCII has stood for all these years, which are basically two pillars, I would call it. One is protection of consumer interest, and the second is responsible advertising. One is consumer facing, one is more industry facing, right? These are the two objectives that we've also always worked for. And the CCPA actually adds a lot of teeth in meeting these objectives now, right? I would in fact offer ASCII as an expert service provider to the CCPA, because we've spent 35 years in formulating not just the policies, but also the processes. And we know exactly how to deal with these things when it comes to us. We have a very established and experienced consumer complaints committee comprising equally of civic society members as well as industry members, who actually have intellectual and often hot debates before adjudicating and passing judgment on an ad, because not all of it is in black and white, and mature minds need to navigate the areas of gray before you come out with a judgment. And all of that has happened over the years, and we have the processes in place. Like Raj said, how well, if there is a deluge that happens, the management of that deluge, those are questions I'm sure will get answered over a period of time. But in principle, I would say they help us meet the same objectives, which is protection of consumer interest and responsible advertising. From my own industry perspective, even if I take off my ASCII hat and wear my advertising agency hat, I've always maintained that with great creative power comes great responsibility. And while we have the creative skills and the persuasion skills to move millions of people buy a particular brand of soap or shampoo or whatever product, there is a line that we ourselves morally would not want to cross. At least all responsible creative people would think like that, right? And what the ASCII guidelines do is give you a very good frame of reference as to, and that has also evolved over a period of time. About 5 years ago, we introduced a policy about fairness products, which wasn't there perhaps 15 years ago. And all of these things are evolving constantly, keeping in mind an evolving society. And therefore, I think formation of the CCPA is going to make advertisers and agencies start to feel more responsible about what they are putting out, start to think twice before putting out. But like I said, and as I would agree with Raj, that it would be a shame if that stifled the creativity and the entertainment value or the creative exaggeration and the puffery, people should not take the rules literally, but treat them as guidelines. And therefore, it requires mature minds to see what is actually valid and what is not in terms of complaints.
I think we've lost Suhas.
I think he'll probably dial back.
Yeah, yeah. I think Suhas is disconnected. This happened earlier in another webinar with him as well. So, let's go back to Aazmeen. Just fill in for him. So Aazmeen, what's your take on the advertiser's point of view? Essentially, you speaking from earlier on the consumer point of view, how consumers would benefit. So what's your take on the other side? Because on our panel today, we have representatives right from the creative field as well as from the client's end, and most of our participants are again from this. So he's back. So I just asked her a question, but you could take over and continue.
I'm sorry. I mean, I just got logged off because of the internet connectivity.
That's all right. Please go ahead, Suhas.
Yeah. Thank you very much. So thanks a lot, Subhash, for that initial comments and your take. Of course, ASCII has been doing a phenomenal job, and you briefly touched upon the topic, which is very, very sensitive, and which I'm getting different answers for different persons. You said, with great creative power comes the great responsibility, and I think I'm going to request, and I'm going to start off with Raj in terms of understanding. Does this law today prevent or has restrictions on that creative license, which is probably the central theme of any advertising communication? Raj?
Does any law, by its very definition, is meant to define certain parameters and so on? So whatever are the parameters laid down by the law, they say misleading. If an advertisement is misleading, it will be a problem, right? Now, that the definition of misleading is not sort of clearly outlined specifically in the way at least the act has been verbalized. And if the misleading piece is left open to interpretation, so to speak, I'm going representing creative agencies, all creative agencies. I'm going to say, speaking for all creative agencies, very definitely, that we should not see any restriction of any sort. We should continue business as usual. We have always operated with a certain degree of responsibility, as I mentioned earlier, which is due diligence as far as so we work with advertisers who are entirely scrupulous in what they put out in the market, right? And you do your due diligence in terms of figuring out what those products and features entail, and get enough knowledge from the advertiser per se on that. And you build your your communication on the basis of that. Within now, when you create the creative communication itself, there will be times when you use hyperbole to make a point. I feel that, like in the case, just to draw an example, when you use animals in an advertisement, you say no animals were hurt in the making of this particular piece of creative. You have to ensure that you are putting down very clearly, a message right at the outset that there are pieces that are dramatized to make the particular piece more interesting. The problem that may happen, and this I cannot right now exactly forecast what will happen, but the problem that may happen is that this is a, how do I put it, what I perceive as extreme exaggeration, another person may take completely in his or her stride. And when you put the power in the hands of the consumer, and it is entirely, creativity, as we all love to say, is entirely subjective. So there is a possibility that there will be different people responding differently. Having been at the center of creating a lot of ads that have used hyperbole, I can say for certainty. So I'll draw upon an example. Some years back, I mean, there was a particular piece of creative that I was at the center of making for Hall's, the lozenge, which is Hall's mentholyptus, from the Adams, which was then bought over by Cadbury and so on. So there was a commercial that was done where when the guy pops Halls in VT station, we actually had him dancing with a polar bear. Now, in a scenario like that, you can say that that is exaggeration of the highest degree. In the heat of summer in VT station, how can you envisage a polar bear? But that is creativity, right? And that we have not received any consumer at that particular point in time. And I'm talking, this was, I think, 12 years old piece of creative, if I'm not mistaken. I don't recall there being any consumer complaints. If anything, it was enjoyed, it worked for the brand, everyone is happy. In the current scenario, if a consumer chooses to complain saying that I hate Halls and I did not dance with the polar bear, then the way to deal with that is, again, sort of weeding the chaff from the grain when it comes to dealing with which consumer complaints to sort of really entertain and which not to. Because if you start stifling this piece, creative agencies are going to be very, very, very hassle. And I would never say that we should be exceedingly careful in terms of the hyperbole that we choose.
No, thanks a lot, Raj, and that's a perspective which is very interesting. I'm going to request Ashwani, because I think there are two elements that I would like you to consider from the point of view of creativity. One is you have disclosures that are mandatorily required to be made on a particular product. For example, your TFM on your soap, it's something which you'll have to mention, because I think the law will force you to do that. Now that's the disclosure under a particular statute. Now you have another claim which is going probably hand in hand or going beyond, making it exaggerated claim on the advertisement. How now do you see the manufacturers or advertisers actually looking at their communications very, very closely, more closely than probably they looked at about 6 months ago? And does this change from perspective that does an in-house lawyer today sit in media communication discussions right up front?
So thanks, Suhas. I think great question. So company like us, basically do have an entire system to scan through any advertisement which comes out before it is launched. So we do have different forums wherein we actually sit across and look at the advertisement from different lenses, including consumer perspective and whether it complies with the laws of the land, etc. And it's a multi-function, committee which basically looks at the advertisement or a claim and give their perspective. For example, in HUL, it will be a R&D person who will pitch in, legal will pitch in, regulatory will pitch in, and then finally the claim is basically approved for the market. Now the second thing you asked is that apart from a statutory labeling requirement which comes from the law, are we going to make additional disclosures? To answer to that question, I think yes, wherever we feel that there are requirements and we should give disclosures to the consumer, I think we are already doing that in that space, and we will continue to do it very clearly. I think one more thing I would like to mention here, Raj mentioned in this comment that misleading definition per se currently is not been described, which is right. There's a definition there in the Act itself, which is quite vague and quite broad. But at the same time, if you look at the guidelines which have recently come in, I think it's quite detailed out. If you look at the whole structure they have, they start with what are the conditions you need to satisfy for any advertisement to be a valid advertisement. And then they go on to say in which situations you cannot be seen as imitating some advertisements, or maybe in what situations you can do comparative ad, or what will be a bait advertisement or surrogate advertisement. In fact, they have also covered the puffery part, Raj. So they've called out what will be the definition of puffery. It can be an exaggeration. So that element has been factored in the guidelines. Of course, there are certain elements which will basically impact the creativity angle that we can discuss later. But at the same time, that liberty has been given. I think they have detailed out in the guidelines very clearly. And we as an industry are currently working on to make sure that angle of, it should not basically hurt the creativity when we finally come out with advertisements. That's where we are. I hope it answers us.
I have one point to add to that. When Raj talked about, one is this whole creative exaggeration and puffery part of it. Like Raj said, it needs someone to understand, separate the wheat from the chaff. But even when it comes to basic misleading claims and the kind of claims that come before ASCII a lot are to do with product performance, right? 5x faster, 3x stronger, or lasts 8 hours longer, right? All of these claims require strong substantiation, which I'm sure companies like, Ashwani was talking about, Unilever and everybody would definitely be prepared with the substantiation. Now, sometimes that substantiation is an in-house one, which comes up against review. Sometimes there are independent authorities that they get to substantiate these claims. Okay, and that is where most of the performance-led misleading ads conversations come into play. I think one of the issues here, which I would like to flag off, and if you look at the ASCII process, okay, one is the adjudicating of the mix of the CCC members who are actually discussing this, which is from civil society as well as industry. And that balance is very, very critical in arriving at a proper judgment. The second thing is the principle of fair justice, which is our processes make sure that every advertiser against whom a complaint has been made has a fair chance to present their case. It's only the complaint as well as the advertiser's statement that is then taken to the CCC for discussion. And I think that is something that it should not be just a one-sided judgment being passed. I think every advertiser who has put in a lot of money and effort into that making of that claim should at least have a fair chance to explain and present their case. And that should very much be part of a fair process.
Yeah. Subhash, if I may add quickly on this one. So you're right, absolutely. But even the framework which is coming from the new act, it does talks about that. So for example, whenever the complaint is being filed, as I spoke earlier, there are definitive powers for the DG to investigate the complaint first and then come back to the authority that this is my finding. And basis that, it's not going to directly, the central authority is not going to directly come out with a penalty. They're going to call the advertiser and the relevant people and take their bills before they finally impose a penalty. Of course, there are criminal prosecution as angle also attached to it. It's really strict in that sense. But of course, there's a due process which has been also carved out in the overall framework.
No, you're right, Ashwini. I think as we understood from MRTP days, there's a notice of inquiry that the DG will issue, and DG will conduct his own investigation. Here comes district collector in the new enactment who will help DG come to the conclusion on investigations. But I think I'm going to go back to Aazmeen in terms of her view on creative license, her view on one of the very critical way somebody looks at creativity is when the regulations are very hard hitting and they're very stringent. I think the creative minds work very well. And therefore, everybody has been saying this act doesn't come in the way of creativity. But If the apprehension is what Raj said, that if I've eaten a Hall's tablet on VT station, I need to kind of feel like a polar bear. If not polar bear, but I should at least feel cool. If I don't feel cool, am I aggravated? Is there any injury caused to me? Is there any damage caused to me? And therefore, that fear that somebody may sue you, will that really affect the creativity, and how would it affect the creativity? Aazmeen, your views.
Sure. That's a great question, and to my mind, the fear should only come in when you're not sort of communicating what is correct. So if we see the definition of what's a misleading ad in the Act, it doesn't thwart in any way the creative license or freedom that an agency or an advertiser should have to advertise his or her product to the masses. All it does is it actually prevents you from falsely describing a product or service in a way that it shouldn't be, because it's not in alignment with what your product or service is. Or, for example, it doesn't allow you to give a false guarantee insofar as your quality or quantity of your product is concerned, or the nature of your product or service. Now, putting it very simply, it gives you a representation either through express means or implied means, by which you could actually be engaging in what we call as an unfair trade practice. So comparisons are wrongly made. Consumers led to believe that your product is far superior than another party's products, or it's even superior to its previous own product version, and consumer is out to purchase it on the basis of your communication. In India, particularly, or it deliberately conceals important information which you should be voluntarily giving out insofar as your product or service is concerned. So when we talk about, let's look at some very basic examples which people can connect with very easily. Now we've just finished, or we're in the through of finishing with our admission processes across, different educational systems in India. And there are a lot of educational academies, institutions. Then you have coaching classes, which sort of set out, that they offer 100% product, 100% job placement guarantees. When in fact, when we check with them, we find out that that is not quite true. Then you will find people who will set out and state that they have the top rankers coming out from their colleges or their schools or their coaching classes, when in fact that's not true, and on the basis of which they garner more admissions. Let's look at weight loss products. A lot of people claim that you would lose weight dramatically in a matter of days, weeks, or months. And they talk about kilos in 20s, 30s. It's all very aspirational for the claimant, who will look at it and say, what's in it to try these products? And they don't realize that this could actually be harming their health in the long run. So when we're talking about loss of money or loss of health, these are very serious concerns that consumers could face. And so all that the Act, to my mind, seems to be suggesting is that by all means, use your creativity to kind of advertise your products and services, which is a great way of, thinking differently and sometimes even entertaining the audience in the bargain by doing that. So humor is very well accepted as well, and nobody is going to stop you from doing that. All we're saying is be honest in your communication. Don't misguide people, don't mislead them one way or the other. Be honest, conceal. So for example, if you buy any product around the world, you will always have allergic information stated on the product. Now, even if you have a chocolate, and if they're probably, manufacturing it on the same line where a peanut was crushed previously, it talks about the risk associated with that for this product, even if there is no peanut in the product. However, you wouldn't see that in a Lay dairy milk or in a Lay milk chocolate in India. And I'm not saying that the FSSAI hasn't done a grand job insofar as their guidelines are concerned, and which currently govern the food industry. I'm just trying to say it would be incumbent on the advertiser to go that step forward and put themselves in the place of the consumer, to just sort of make sure that they're kind of, at the end of the day, as David Ogilvy had said, don't lie to I'm not lying to your wife, don't lie to mine. So the point is that let's be honest in our communication. Let's put it across in a way by which the consumer is at the heart of it. And then you have nothing to fear insofar as any enactment is concerned, be it this or any other.
Thank you very much, Aazmeen. That's very well put there. You see, I'm kind of still getting very, very confused overtones here, honestly. And I'm going to kind of request Subhash to, come to my rescue, because, what is now ASCII's role? ASCII was considered to be a kind of a B2B private club, honestly. There were lots of, issues when you looked at ASCII, and one predominant was it didn't have a regulatory or legal mandate. It was not legislative body. It was self-regulating, self-governing body on its own. But there were kind of rumblings to say that it's a very private club. It's a B2B body. Consumers are slightly remote compared to ASCII, and that it's not a completely a body where a consumer in a remote area like Raebareli could be able to kind of make a complaint and ensure that his matter would get probably adjudicated. Okay, it was a very good self-regulatory body amongst very few. And that there was an advantage or a disadvantage that was taken by the competition if it were airing competition. Now here is a complete democratization of advertisements, misleading advertisements. Adjudicatory forum has been completely democratized. You see, they're bound to be, one is rogue element I can understand who are not protecting the rights of the consumers and are not responsible. They need to be pulled up together. That's fine. But there are few who take the advantage of the situation. There are proxy litigations that will happen. Like, Ashwani alluded to, surrogate advertising happening. In various of such forms, would therefore unethical practices now increase? And in that sense, what would ASCII's role be? Will it continue to kind of tell the advertising agencies and the advertisers that, sorry, your ad is a misleading ad and wrong? Or would you now say that, let's see, there is an act and a regulatory authority, so let that regulatory authority decide? Subhash.
There are quite a few questions that you rolled into one, so I'll try and simplify the threads one by one.
Thank you.
First of all, is there a role for a self-regulatory body to exist when with the creation of a strong government regulatory? I think yes, it absolutely does. If you look at all the developed markets in the world, whether it's the US, the UK, or Australia, or any of these places, they all have strong government regulatory bodies in place. And they also have very successful self-regulatory organizations coexisting from the industry, right? So the concept of self-regulation is, I sign up to commit, not to cross a line, right? And that responsibility continues. I think for advertising and for marketing to become more responsible absolutely needs to continue, okay? I mean, I have a analogy, just because the police is there doesn't stop us from teaching our children the difference between good and bad, right? Or the right and wrong. That process of educating, the process of making sure that people understand the guidelines that they should not cross, that job should absolutely continue. So I don't believe that it's one replacing the other. I think both have a role to coexist. And like I said, we really want to partner with the government on this.
No. Yeah. See, Subhash, my point is slightly different. You see, when you have somebody who is going to exercise a legislative power or an authority, in a sense, what that CCPA is going to do is going to be laying down the law on a particular advertisement. Let's take an example, correct? If you take a view which is contrary to what CCPA is taking or has taken, in that sense, people are going to say that, why do I waste my time with ASCII when CCPA is going to adjudicate? I'll tell you what, very clearly, and I can draw a parallel between SEBI and SAT. You see, SEBI is on-the-spot regulator. SEBI kind of works because it has to work as on-the-spot regulator. So the test for evidence is not beyond reasonable doubt test insofar as SEBI is concerned. It is theory of probability there. And they rule based on the probability. Every order passed by SEBI, or 8 out of 10 orders passed by SEBI, are set aside by SAT. Because fundamentally under law, SAT is bound to look at beyond reasonable doubt as a test of evidence. You see, that's the difference. And therefore, if CCPA is a legislative authority or a body or a regulator today, and you are in the same field as CCPA, if CCPA rules differently from you, or you rule differently from CCPA, because the manner in which you're going to interpret the guidelines and the standards is bound to differ. In that situation, why would anybody want to come to ASCII and not go to CCPA?
Because
That's
of
the conflict. That's the conflict.
Because of the idea of self-regulation. My whole idea is not to go into a situation where I'm going to get penalized. No? I need to understand where and how responsible advertising and marketing needs to be. What are the guidelines? And therefore, the idea is not to take it to that level in the first place. Secondly, I don't strictly believe that all cases are going to be contrarian in terms of opinion between CCPA and ASCII, because I think if I look at their guidelines, their draft guidelines, they are very much with sync between what we've been practicing as well. The guidelines are exactly worded also very, very similar. So I don't foresee, of course, there may be some points of difference at some stage or on some case, but we'll have to take it as it comes. I don't foresee, I don't see why that would be an issue in generality. There may be exceptions where there may be differing opinions. And yes, they have the penalizing power, and that's what a legislation is all about. Luckily for us, I mean, if you look at our past records, there's been an extremely high level of compliance from our members, okay, without it having to go to legislation. Very high level of compliance. Raj pointed out, whether it's a correction of an ad or withdrawal of an ad or whatever, we've had a because those members are mature people who have signed up for this, right? Now, in some cases where there is a refusal to compliance, we actually now have a higher authority to take it to. We can pass it on to the legislature as well, right? And then this is contravening the law, whatever it is. So I think, look, it's just a new thing that's been introduced. I think there'll be a lot of questions that will be coming across. There will be a lot of teething issues. There will be things that will evolve. And I think we need to work together on this. And it will take time before it becomes a very smooth operating system. Just as at ASCII, it's taken us a long time to arrive where we are today. And I'm sure it will take time for infrastructure to be put in, etc., etc. And we would be happy to partner on that journey.
Actually, if I may.
Sure, Raj, I was going to come to you. Yeah.
If I may, just picking up from where Subhash left off. Just going back to your question as well, what is the need for ASCII to sort of, people to go to ASCII in the presence of with the presence of a CCPA now in place and so on? If anything, I feel genuinely that there should be a way of figuring out how CCPA and ASCII can join hands. Which is that, because I feel, I mean, the ASCII, what it has been doing, what the body has been doing, there's no doubt in anybody's minds, whether you're advertiser or agency, that most of the feedback that comes from ASCII when it comes with regard to the guidelines of creative product, because of the kind of, and I know the kind of people who have been on that, on the committees of ASCII and so on. Subhash himself now is the chairman, the newly appointed chairman of ASCII and all of that. So very seasoned campaigners, guys who really know, who are long in the tooth when it comes to the whole process. That knowledge should be leveraged by CCPA, if anything.
I understand.
Then you're talking about at least, I feel, a greater ensuring of success when it comes to dealing with the kind of comments that come, because there will be experience / knowledge related issues, I feel, at the CCPA level in comparison with the kind of stalwarts who have served on ASCII.
That's right. No, absolutely. I mean,
Right?
that point well taken.
Yeah.
So Raj, I mean, I'm going to continue with you for a very different track altogether. When we talk about advertisements, misleading advertisements, and coming round now to endorsements, you see, which actually talks about every endorser has a defense today to say that if I verify the veracity of the claims of the product, then that due diligence being available to with the endorser or with the celebrity will be a good defense, and he will not be liable. Although there is no immunity from prosecution, but he will not be liable. So at the prima facie stage, somebody might say, here is a report, independent third-party report, which was given to me, which is like, I have verified all the claims that are there in the ad. Now, in terms of the process of communication and process of producing the communication or developing a communication campaign, at what point in time you will look at this aspect so that you don't have to rework. I know quite a few cases where actually the ad went up to a level of being released, and it was forced to be retracted. You see, and the very popular example, a very old example, and Ashwani, please pardon me for taking this as an example, was when actually war between Rin and Nirma broke out. You see, a very creative ad was there, which said that Lalita ji, Aap bhi was a Nirma ad. When very creative, but I think it got rolled back. It got rolled back for various other reasons, and one of the reasons was a regulatory challenge there. So, are these instances, and these instances force one, of course, at what level you look at the due diligence, at what level you look at the legal issues brought into the communication. How would you look at, will that change, or will it continue the way it is currently?
See, since you brought up this example, I think any time an advertiser or the advertiser's agency resorts to using either the brand name of the competitor or in the Lalita ji case, the so-called endorser, and she wasn't a celebrity endorser, it was her name in the creative, right? But she just sort of became part and parcel of our consciousness, because at that point of time also there were fewer ads and so on and so forth. So everybody just remembers that character even today, at least people of a certain vintage like myself and so on and so forth. So the point being, when advertisers and agencies indulge in competitive advertising of this nature, I think they also do it fully consciously, right? Fully aware of the fact that there may be action which I may have to deal with, and but if I can, the very fact that you brought up the example of an ad that virtually did not run,
that's true.
It says that it is successful in its job, in the intent that it was created for. So I think that sometimes these things also come into play because of so they are fully aware of the nature of creative and what it sets out to do. And if there is action or legal action that is pursued by the opposite camp, then they take action, the necessary action, as sort of comes into play when it is sort of called upon. I think it's done eyes wide open. There have been enough instances of brands going hammer and tongs at each other. Sometimes both brands have succeeded, and sometimes one brand has sort of had to pay. There's lots of examples in this space, I'm sure. But I think, again, I don't see, therefore, as a result, competitive advertising suddenly taking a backseat and people becoming extreme. Anyways, the consumer, since this act is supposed to protect the consumer, is not going to be, would never have had a concern about Lalita ji, the creative, going out, right? That's the advertiser, very clearly in that case. So that was a battle of the two advertisers. In our case, that won't even come into play, honestly. They'll, if anything, actually going back to what Aazmeen was saying, they'll find it entertaining.
Okay, no, I take your point, but I'm going to come back to Ashwani ji on one aspect, you see. And I think HUL, since the time I was working there, which is probably 86, 87, since that time onwards, I have seen, people are wanting to get back to HUL. They would always want to throw stones at the leader. They would, and therefore there are lots of these, anti-competitive kind of tactics that everybody would deploy. And therefore some of them are unethical in nature. Some of them are really nasty. Would that increase because of the new enactment?
See, as of now, Suhas, as we were discussing, as of now, the complaints are normally filed with SK and you deal with them. But given that the scope has been enhanced currently, wherein the complaints will be now can be filed with collectors, as we were discussing earlier. So we feel that there will be a chance that the number of complaints can increase. But having said so, if you have done your homework in terms of ensuring that you are complied with all aspects of law, we feel that we'll be able to fairly bat it out and defend our advertisements. But at the same time, of course, that risk always remain when you are being prosecuted. So in that sense, yes, the risk we feel increases. Given the fact we have not also seen currently that this is a very new framework which we are talking about. We don't know how collectors will behave in terms of the investigation they are going to do and how the central authority will take views on the misleading advertisements. Of course, SK has been there for 35 years. We know the kind of recommendation has been made, how the law has evolved on the subject matter. But I think this is a new, regulator who comes in and play. It has to be seen how, they take an action and what kind of positions they take in near future.
Yeah, sure. Thanks.
Just a couple of points, I think, just to add on to what Subhash was mentioning earlier. I think in the context of the fact that, your question was around, since the regulators in the picture, the role of SK, I believe that there's certain provision wherein we basically mentioned that in case there is a matter which is sub judice before an authority, in that case, SK will not proceed with the hearing. So that's something which is existing provision. Of course, sub judice is in the context of court hearing or maybe a complaint before a consumer. I don't know whether the scope can be expanded to any investigation which has been, started by the, central authority or maybe a DG. That we need to be, looked into. And on Raj's point on involving ASCII, I think this is one point we really want to do. And from last year onwards, we have been recommending the central authority and various government organizations that under 13(3), government has the power to appoint experts. And we really have pushed hard. The government can appoint ASCII as an expert given the experience they have in the subject matter and support the central authority in discharging its duty. So that's been a push we have been working towards.
No, thank you very much. I'm going to come back to the, as Subhash mentioned yesterday, elephant in the room, which is like the endorsements, you see. And I think one, of course, endorsements, one can put any number to that industry within advertisement space. Somebody puts that number to almost about $500 million in India as the space in endorsement. Every celebrity kind of endorses and looks at this as a revenue stream there. And it has been, and I think, Subhash and Raj would probably know this much better than I do, but India as a country is probably very high if we start ranking on endorsement businesses. India would probably rank amongst top 2-3 countries in the world. It has its own economy, so to speak. Suddenly, with this law coming in there, and there was a lot of talk earlier also, there was one private bill which was kind of introduced way back in probably 2001, 2002 to say that every celebrity should be held responsible if the advertisement is going bad. From there onwards, this space was very clearly looked at. What has been picked up today as a consequence of endorsement going bad, in a sense, endorsement is part of an advertisement. If advertisement is considered to be misleading, as the law says today, it's a misleading advertisement. That's part of the endorsement there, dovetailed within it very clearly. And therefore, if it causes injury to the consumer, or if it results into unfair trade practice,
I think we lost Suhas. Suhas, are you
Lost
there?
Suhas, I think.
Yeah.
Should we continue on the topic while waiting for him?
Yeah, we can. So
I suppose, yeah, sure.
Yeah, please go ahead. I think with connection, there is always going to be a problem. Yeah, Subhash, please go ahead.
Yeah.
Please.
So I think the question that he was leading towards, given that celebrities and endorsements are such a large parallel economy, as is the word I think he used, so much of rupees being spent on that. From a creative industry and from an advertiser perspective, I can talk from an agency perspective. Why don't we opine on what this law can mean to them? Raj, perhaps you would like to go first?
No, carry on.
Let's say you're signing up a big film star, 8 crores, 6 crores for a commercial that you're going to pay that person, or whatever the announcement money is. Now, there are some very strict guidelines that have been put when it comes to endorsers in this draft, and especially penalties, which are fairly severe, right? What is your point of view on what do you think the impact will happen? I mean, what is it? How will they do due diligence? All this while they've said we are just actors, so we just say whatever the director tells us to do.
Correct.
But I think the act is saying that no, you have a huge influencing and persuasive power over your fans, and therefore you need to be responsible and accountable for the message that goes out. So you need to do, Mr. Celebrity, you need to do your due diligence before going and speaking on behalf of the product.
I think it's fair to say that finally celebrities will actually be earning the ridiculous amounts that they're paid. Right? They will need to do, like you said, the due diligence on the product, what exactly it is that they're endorsing, finding out enough.
Suhas is back.
Yeah.
I'm sorry, please continue.
Yeah.
So we were just keeping the audience entertained on the same topic that you started, then you dropped off. So we haven't gone away from it. Don't worry.
Yeah. So yeah, I think they will truly have to really earn what they are earn the money in terms of what they are being asked to say about X product, Y product in that sense. They will have to find out a lot more regarding each brand that they're endorsing. I think they'll have to dig deeper, which goes without saying. I think it brings a lot more responsibility on their shoulders. The power to influence will finally be sort of underscored with the power of responsibility of that particular influence. The amount of money that they are obviously being paid to make these endorsements, it has, like Suhas mentioned, the parallel economy that he referred to, will finally really sort of come into play, right? They will really earn their keep in that regard. I think that I think that if they are the face of, let's say, a weight loss product, like for instance what Aazmeen was mentioning as an example earlier, the need to really find out through the kind of studies that the advertiser has brought into play while developing, in terms of understanding the R&D that goes behind that particular product, really getting below the superficial levels perhaps at which some of them may have operated today, may not necessarily continue to allow to be the case anymore, because if they are asked uncomfortable questions, they better have the answers, and that can only come out of, like, in the case of any relationship between an ad agency and an advertiser, you ask the relevant questions that gives you enough knowledge about the product. All endorsers, the biggest celebrities who have the power to influence, will have to do the same. I think it's fair to say that some of them, I believe, do try and get under the skin of a lot of the products that they endorse, but maybe there are some who don't. And now that choice will no longer remain, because they can be taken to task, is the way I'd put it. I think the other point is the fact that I think Ashwani touched upon it very sort of briefly earlier, which is the whole definition of the endorser. There is the super A-class celebrity versus the online influencers on Instagram and so on and so forth. Everybody is doing product endorsements. Where and how and when does their exercising influence come under question? Who questions them? Those are things that need to be sort of watched out for, in my opinion. So this is also at one level, therefore, for them to sort of consider when they are picking up a brand and talking about each brand. They should be concerned about what they're saying about each, and nothing should be on the basis of fluff. It should absolutely be based on hard fact and no fiction.
Yeah, sorry, Suhas, just a supplement to this, which I, if you remember, asked at another webinar where I participated, and this is to all the agency guys. So some of the big bucks are there from a kind of advertising today, which is not really, very reliable. Let's say the real estate industry, and we know what's happened. Let's say in some of the Gurgaon, some of the Noida properties where Dhoni had endorsed some of those, and he was taken to court. Similarly, as you know, real estate in Mumbai again is under a lot of pressure. Would this be given a complete bypass by some of the stars, or because what due diligence do you do in something like this?
No, are you saying that they will not? Are you asking whether they will therefore stay clear of real estate as a category?
Yes, or get indemnity on something like this.
From an indemnity perspective, I mean, I'm not the legal expert, obviously, but from an indemnity perspective, if they are offered that, if that is on the table, then I'm guessing that they will exercise that option, because they will seek to protect their interests, obviously. But categories where so celebrities are also extremely, especially the A-class celebrities, as one would put them, are extremely astute in these matters as well. They also operate with legal counsel regarding what brand they should associate with, what fits their personality. They do, at least some of the better ones do these things. The ones who are just not discriminatory in these matters will continue to sort of try and endorse everything that they can lay their hands on. But the ones who do their due diligence, I feel, will always be safer in that regard, right? That goes without saying.
And as a category, let's say real estate as a category, because very high risk at the moment.
It's a high risk. I think it's maybe as risky as a weight loss category. I really wouldn't say real estate is riskier than something like that. I'm not entirely sure, unless Subhash has a different point of view here.
No, I think it comes down to the claim, actually. What is it that you're endorsing? Let's say in real estate, suppose the advertising is all about the percentage of greenery to concrete areas that we have created in this beautiful complex, suppose, gives you a natural kind of lifestyle. That claim has to be substantiated by that much amount of greenery in that place, right? But if there is a problem or that real estate company is sued for something else, which has nothing to do with the ad, then I don't think the celebrity or whoever is there in that ad is responsible for that. No?
Correct.
I think ultimately it will come down to specific, what is the claim? Is that misleading or not misleading? Is that substantiated or not substantiated? Then if
Yeah.
a celebrity wants to stand behind that claim, it will come down to that specific issue.
So the one which got into a problem in Noida was essentially where Dhoni was endorsing the entire project, and the project got shelved, where the promoters went bankrupt. That's where the case went to court, and so that's where a bigger problem is, because a lot of these big properties here are endorsed by.
So Sandeep, this is one of those where obviously Dhoni as a celebrity would not have seen coming. Nobody can predict. I mean, but real estate being real estate as a category, the possibility of a project being shelved is extremely high, or being taken over by somebody else midway through the project, and so on and so forth. I mean, that happens all the time.
Unless he was a promoter as well.
Oh, that I don't know. I don't know.
Or maybe I think one of the claims can be timely delivery of the flats, etc. If the timely delivery is something being called out, I think then he can be held up in the new act.
That's a classic. Yeah.
So Suhas, over to you. Sorry for interjecting.
No. Sandeep, I think you raised a very interesting question in terms of real estate, because you see the way the definition is in terms of endorsement is that a consumer is made to believe. You don't have to have necessarily claims which are quantifiable in nature and very objective. If a consumer has been made to believe that so-and-so builder developer is a very reputed builder developer. What is a reputed builder developer would mean is actually he is delivering his projects on time. Would be implicit in there. If I were wearing the devil's advocate hat, I would say yes, implicit in that being reputable is that you're delivering your projects on time, and that's Ashwini's point. Therefore, if the project gets delayed, right, then I have purchased the flat based on this advertisement and a belief that this builder developer is reputable. And therefore, can I then sue the endorser? Of course, legally one can sue anybody at any point in time. And this is a new law, and we'll talk about unfair kind of contracts related provisions that have come up, which I think very few people are today talking, but there's a huge kind of unfair contract stuff within, and the product liability built within the new Consumer Protection Act. Now we'll have to read this together. But before coming to that, I would simply say that this aspect of an implicit communication there saying this reputed builder would mean I take it as the project will be delivered on time, and therefore to that effect it becomes a misleading advertisement, it becomes a bad endorsement, and I've suffered injury, so to speak, for a compensation claim there.
Yeah, absolutely. And so that's what I was mentioning the other day, that there is this vulnerable section of society where they don't do all the due diligence. So people who are quite informed and have various tools at their disposal would always look at all the due diligence before investing. But we've seen as to how the association with Sahara Star, with having all sort of Subrat Roy and lakhs and lakhs of people just invested their money because he was associating with so many celebrities. I think the Consumer Protection Act is essentially aimed towards them and not towards people who would, when they're going for a 7-8 crore property, wouldn't just go in because a celebrity is endorsing that. I think that's where the challenge is going to be, and that's where the Liability examples where somebody would just go and have a celebrity endorse something, and people would, all the chit funds are still stuck. So that's where all the association, so I think that was what I was essentially alluding to.
No, thanks a lot, Sandeep. I think that's an interesting element and area. I'm not sure whether any of the celebrities would forego their revenue stream. You see, unless you have really deterrent examples where they've been prohibited for 3 years. So I'll just go around with everybody from Aazmeen onwards and try and understand. You see, Aazmeen, what do you think? Would a celebrity actually, expose herself with this kind of a law, where there is a possibility that if your claim is considered to be misleading, if your advertisement is misleading and therefore your endorsement has gone bad, you actually lose out 3 years revenue, because for 3 years you will be prohibited from endorsing any other advertisement. Forget about that particular advertisement. So what's your take? Would you still will you still continue to look at that as your revenue stream?
From a celebrity's perspective, I suppose they are going to be far more cautious going forward. And if, firstly, many of them are not even aware about this provision, in spite of the amount of talk that's going around through different media circles on it, you do have sports persons and so on, individuals who really aren't abreast about the provisions of this law yet. Fortunately for them, they have agencies which manage them and who would probably take care of their interests. Having said that, I'm sure they're going to weave in with the help of legal firms and their own set of counsels who are going to advise them on how to protect their own interests and their own compensation. Because at the end of the day, even if they take any sort of indemnity, as you've mentioned, or insurance from the advertiser, there's no saying, how much of the authenticity of the product claim the advertiser is going to genuinely share with the celebrity or with the endorser. Let me put it as an endorser, not just a celebrity. It could be anybody. So, and this doesn't just impact the individual per se, or the firm or the institution, because it bars them from advertising, as you said, from 1 year at the first instance to 3 years of on multiple instances being found of being caught on the wrong ground insofar as in misleading advertising is concerned. It also impacts the other advertisers for whom they have endorsed their products for no fault of theirs. So if I'm barred from advertising X product, why should A, B, and C products suffer from the ban that I am levied on just because I have endorsed X product which has been found to be misleading in nature insofar as advertising is concerned? Now that is something that even the advertisers are going to find as a matter of grave concern, and that's something that maybe they need to contemplate upon when it comes to interpreting this law.
No, we've already started advising on the cross default and kind of cross event happening across as material event or obligation resulting into material obligation resulting into termination. But that's very well said, Aazmeen. Subhash, will the market go down? Will you see some adverse effect on endorsements?
I don't think so. Look, as some people pointed out, I think there will be a more cautious approach. There have already been cases where a top celebrity has asked for some kind of due diligence and stuff. ASCI has always, for its members, has had a service called the creative advice, where you could bring a script or a storyboard to ASCI and get their advice even before you put crores into production, right? Can a similar kind of advice be extended to endorsers? Yes, it can. However, that it's advice. It's not any guarantee or a certificate of. There could still be a complaint against you, and you'll still have to go through all the process. This is only a kind of a safeguard. So, are there areas that could be? I think the issue of due diligence becomes larger when celebrities are agreeing to endorse products which need technical substantiation of the claim.
Okay.
Whether it's a technical thing for products claim, right? Faster, smoother, longer, darker, fairer, whatever the claim is, and there is a technical substantiation. Where can they go today to get that due diligence done? Even if, there may be, celebrities are as human as us, right? There'll be some people who are more cautious and some less risk aware, and some people who will say, kuch nahi hoga, chale karte hain. I'm sure there'll be different types of people in that whole lot, right? But even in the person who wants to do due diligence today, one is to tell the advertiser, you have to indemnify me if something goes wrong, that's a different conversation. But suppose a person wants to do due diligence, where does he go today? I remember the famous. I mean, their stance has always been, "I'm just playing a role, yeah. I'm just playing an act."
Acting.
No,
I'm
you also
acting.
have but see, when Amitabh Bachchan acts as Don, as a smuggler, I don't believe it because I know he's playing a character. But when he comes on screen and shows me a chocolate and says, "This is safe to eat," I believe. And that's the power, right? So there is a responsibility there, right? There is a responsibility there. Now imagine Mr. Bachchan is going to get crores. Now what due diligence is he going to do? Have to go to the factory himself before coming in front of the screen. I think he did that in Cadbury's case, right? And he came and said, "I vouch for this because I've gone and seen it personally myself." But what about technical claims of the perfume will last on you for the whole day? Is he going to wear it himself? I mean, those are the issues. So while there are penalties, there should also be parallel services provided for these things to help them. But coming back to your original question, I don't think there'll be a dip in endorsement because it's not. Endorsements are there, like some people said, at a top celebrity level, going down all the way towards internet influencers, that whole ecosystem, right? But I think the law will make them more cautious. And personally, I hope it does.
No, thank you. Thank you very much, Subhash. Raj, what's your take?
Actually, when I made this point earlier, what I was saying was that I believe genuinely that celebrities will really earn the big bucks that they get for endorsing brands by, choosing to endorse a specific brand, because especially the A-list celebrities who you really look up to. So if you're talking about an Amitabh Bachchan or a Shah Rukh Khan or you will expect them to dot their I's and cross their T's, because if not, like in the Dhoni case that Sandeep mentioned, if they get caught out and it works against them, then obviously that becomes a huge sort of problem for them, because the moment a problem happens with any celebrity, all advertisers will tend to sort of veer away then in the future from that that also tends to happen. There is a little bit of whoever is the flavor of we also tend to do that when as whether advertisers or ad agencies. There are always there are flavors of the season, so to speak. Of course, there are great celebrity endorsements at times where the match between the brand and the celebrity is fabulous, like the example that Subhash just took about Mr. Bachchan going to the factory and seeing the process of the chocolate being made, and this was when that whole controversy had erupted and so on and so forth. But that was very well received by the world at large, right? So when that kind of diligence happens, it's great. It's when specific claims come into play, then it becomes a problem.
Thank you. Ashwini, I'm going to come back to you on a very critical element on the endorsements, because you see, HUL is one company where the personal products carry endorsement directly, implicitly, whichever way. You can't sell Lux without there being endorsements behind that brand. There are people who say and believe, and I'm just going to go back and trace it back to one of the earlier bills that was introduced as a private member bill in Lok Sabha and Rajya Sabha, which said that the fact that endorsement is happening would mean implicitly that the endorser is using that product. I know, having advised Mr. Sachin Tendulkar on every endorsement, I know for sure he was very, very conscious of saying, if I am signing off on Adidas, I need to wear Adidas whenever I'm facing any camera outside the cricket field. Okay, so I must be demonstrating that I'm using that brand. That's very implicit in the endorsement, probably is one claim or one set of people saying so. On the other hand, it's impossible to expect the endorser to use every personal product that HUL kind of markets, whether it is Liril or whether it is Lux. Therefore, there is one theory which says that this is not an endorsement. the advertisement, which is endorsement and which is not an endorsement, is quite categorically cleared out, so that what qualifies as an endorsement should be different. It's not Lux advertisements qualify to be endorsements unless somebody is signing off there and actually endorsing. You see, would you now say that it's a time when you actually embark upon endorsement as an advertiser and as a manufacturer, as a seller, you embark upon endorsement when it is absolutely essential for you to do so? Or would you do away from the endorsements?
That's quite a tricky question, I must say. I don't think we are going away from using celebrity in our advertising. I think it's largely to do with the brand purpose and brand strategy rather than anything else. And as long as we can do that within the four walls of the legal system, I think that's something we'll continue to do it. Now, the question you asked was that from an endorsement perspective, if we are showing any celebrity in any of the campaign, would that mean that celebrity has used the product and therefore endorsing? I mean, we have to slightly take a back foot there and basically look at overall perspective. I mean, as long as the claim or the product which we are talking about, the claim we made about the product is something which we can substantiate or by way of a science or by way of an expert evidence about it, I think that's something which we like to continue doing it. Yeah. Even if you look at the new guidelines which has come in, it does talks about that, it does not differentiate between a person who simply comes in a campaign or, he will be, even if he appeared in any of our ad campaign, they will be seen as endorsing of that impliedly in that sense. I don't think it will be difficult for anybody to say that this person is not endorsing that product when they come in any of our advertisement or a commercial. So that factor will continue to be there. I think the only element would be that, what kind of due diligence this person has done, the celebrity has done before, taking over that assignment. And I fully agree with what we were discussing earlier. I think the money is too serious for anybody to leave on the table right now. I think they will continue to do with what they are doing currently. It's just about, if I look at HUL, I think in last couple of years, the level of seriousness has really increased. The kind of questions celebrities are asking us, what kind of complaints you have received in the recent past? How have you addressed those complaints? So that kind of question, celebrities have started asking us. I see that seriousness have started coming in. At the same time, they were actually primarily relying upon the contractual cover. I mean, in terms of the reputation taken from the company that we have done everything fairly, etc., and that we have given them indemnity, etc. Of course, as a company, we do make sure that a docket on the claim is handed over to the celebrity, and we try and take them through the docket for the claim. But having said so, whether they have read that, not read that, I think that's something still left to be seen. But at the same time, what this law changes is the fact that they would need to ensure that they have gone through it. And if they have not done that personally, I think they have to then rely upon experts like ASCII to give an opinion, or maybe a lawyer giving an opinion to the celebrity, whether the claims in question are misleading or not, Suhas. That's something which is going to play a very, very crucial role in the entire game.
Yeah, I mean, thank you very much, Ashwin. I mean, somebody reminded me we're coming close to 5 p.m. Our time is getting over, but I'm going to do a quick round of closing remarks and probably a brief statement on what should we do next. And I'm going to start off in a reverse order now. Subhash, reverse from the time I started. Subhash, your view and your closing remarks, and how do we look at what safeguards?
My closing remarks are really going to be very close to my opening remarks. I think it's a good thing with CCPA, and I think from an ASCII perspective, we would love to partner with the government to make the processes even more robust using our knowledge and expertise. We've got years of expertise on this, and we'd like to offer that to the government to partner them in any way on this journey.
Raj, you're on mute.
make ASCII work with CCPA. To me, it will just simplify the overall. I think there will be fewer headaches for everybody concerned, whether agency, whether advertisers. I think from a quality of answer point of view, it'll make life simpler for the CCPA, for the committee, and hopefully even difficult consumers will get satisfied.
Thank you. Ashwani ji?
You're on mute.
Yeah, sir. Can you hear me? Okay. So I think a couple of lines here. So one thing is, of course, this is quite a progressive step taken by the government in the context of consumer. So that's one thing. The second element is about, of course, the government is moving really, really fast on the number of regulations and the guidelines which are coming up. We are working with the trade associations to make sure that industry perspective, likewise, celebrity perspective is taken into account. And we believe that government will be taking care of those concerns which industry is putting out right now. That's about it for us.
Thank you, Ashwani. Sandeep ji?
Yeah, I agree with all this, but I think it's too early. We can just find out as to who is going to regulate. Till that is clear, till now, ASCII was supposed to regulate, and they were doing a fine job, as everyone has said, right from the advertising agency to some of the established media. Again, the unregulated one just escaped and did anything. So if you were to go outside Delhi railway station, you will see that those walls had enough advertising running about every kind of product, or you go to the unregulated cable operators, or you look at hoardings where you do not even know who owns that. Those were the ones which were unregulated earlier. Internet, how is it going to be regulated? Nobody knows. Because something will come up and something will go. But apart from all that, I would just like to see that it's going to be very, very difficult for the media owner currently who's struggling. So whether you look at newspapers, magazines which are almost finished, you look at television which is going to struggle. These are going to be difficult days for and having spent all my time from that side of the table, I think when I speak to a lot of my friends who are heading channels or heading print, they are really worried with this act because they don't know as to how it's going to hit them as far as revenue terms are.
Thank you. Aazmeen?
So my closing remarks are, this is an interesting time for advertisers, for endorsers, manufacturers, and as you said, publishers and the consumers. What is also missing is the fact that so far it was the government who managed to escape from the lens of the law insofar as ASCII was concerned, because we clearly didn't look into government ads. Today, the consumer can even complain about advertisements which would be false or misleading by them and make them accountable. So if we're looking at an era of accountability coming in, I think this is a positive one. If we're looking at it being responsible, again, it's a positive one. It requires everyone to strive together for the common objective, and I think we will be well on the path of having honest and good communication out for everybody at large. Thank you.
Thank you very much, Aazmeen. I mean, we have some questions and maybe another about 5-7 minutes that if we can continue.
Yeah, please go ahead.
Yeah, sure. The first question from Vedang Thakkar is that what is the maximum liability cap for damages to compensation under the Act? Further, if there's a contract between manufacturer and seller having maximum liability clause, what would be the effect of the same? And the same question under product liability under the Act. Who would want to take this? Aazmeen?
Yeah, sure. So insofar as damages are concerned, there is, for product liability, there is no ceiling that has been spelled out. So you have your forums which are anyway open for that and you can complain. But as far as endorsements are concerned and so far as misleading ads are concerned, yes, they have put out currently a sort of a stipulation insofar as the fines are concerned. And for that, we have a cap insofar as firstly 10 lakhs for the first instance of default, and subsequently it goes to 50 lakhs.
Thank you very much, Aazmeen. Would anybody want to add on to that answer? Okay, the next question is from Smriti. Could you put some light on whole Nestle Maggie brief downfall? I believe it had greatly affected the brand in spite of being age-old brand, deeply ingrained brand and product. How could they have avoided that in light of current Consumer Protection Act provisions? Subhash?
I wouldn't know the details of that. I wouldn't like to opine on something that was sub judice at a point of time. I wouldn't know. Maybe Ashwani or Aazmeen might.
Aazmeen, we will let you type.
Yeah. So the real source of the complaints were, from several quarters all at the same time, and they were about the amount of lead that was found in the product, which was considered to be harmful for health of the consumers at large. Just the fact that it was found to so many complaints were actually being filed parallelly in different forums with the government led to an investigation in the appropriate laboratories subsequently to find out the merit of the truth of the claim. And ultimately, from all the findings that it was established that if you look at the quantum of lead in the tastemaker per se, which was never the intention to be eaten in isolation, but when you mix it with water, which is how it's supposed to be prepared, it was found to be safe for consumption. And therefore, within a few months, you found that the product was back on the shelves and available for consumers to purchase and avail.
And I think the lockdown helped them immensely.
Absolutely, and in the lockdown, it was the hot-selling brand across. Yeah. I think just to add on,
Parle-G and Maggie, yes.
Absolutely. So what Aazmeen has said, I think the only thing is that the issue was more about unsafe food being declared because of the testing done by food authorities in different states. Not from a sense of misleading advertisement per se. I mean, of course, food laws would have have their own implications, and this food, I would say, it's a different sphere altogether.
It was an FDA regulation rather than.
I don't think that the brand, while of course there was a impact in terms of a lot of their noodles being. I vaguely remember reading in the Economic Times about some tons of Maggie being thousands of tons of Maggie being destroyed and all that sort of stuff. But having said that, in the long run, it hasn't impacted them, right? I mean, the very fact that during the lockdown it's been one of the most popular brands showed how. Also, this was not consumer-led. Right?
But Raj, there is a clear lesson here, because all this happened in very small places in PNMP. None of this was in bigger towns.
Right.
So going forward, this rivalry example we've been talking about has real potential, like Suhas was mentioning about a deluge. So everything would start from there and maybe not in the big city.
Yeah, absolutely.
My take, Sandeep, is that, see, very clearly, if you look at the Consumer Protection Act, it doesn't override any other enactment. You see, it has no provision which is in the nature of overriding provision. So if you have taken an action against Maggie or any food business operator under the FSSAI, which is principle-based legislation, so to speak, you would say that, sorry, consumer complaints can't be entertained because there is an action there under a specific law, and that law has a non-obstantive overriding provision, so to speak, which says notwithstanding anything contained in any other law, if there is inconsistency, this law will prevail. That provision is absent from the Consumer Protection Act 2019, and it in fact says it's supplemental to other laws. So we will come back to that.
I think we have answered that question sufficiently.
Yeah, absolutely.
There's another question from Adrian. It says, if a brand is using non-Indian celebrity who uses the brand abroad but is sold in India with different formulation, how will the celebrity safeguard himself or herself from this? Anybody who wants to take this?
Well, I think legally, Aazmeen and Ashwani can possibly opine better, but I would imagine that in that particular case, where if the claim is found to be misleading, the advertiser who's local would be held responsible by the CCPA. Whether they will have jurisdiction on the international celebrity, etc., I'm not sure from a legal perspective, but I'm sure the Indian advertiser who has used that communication would be held liable on the grounds of misleading.
Thanks, Subhash.
Yeah, just to add here, so definition of manufacturer does include entities who actually get the products manufactured or imported, or basically take it from somebody else and put a brand mark over there and sell in the market. So it does include those kind of entities as well. In my sense, even if you're importing and then advertising and selling in the market, then you will be included in the definition of manufacturer.
Aazmeen,
And from a celebrity perspective, yes, thank you. From a celebrity perspective or an endorser perspective, I don't think we have any carve out for Indians or non-Indians in the law. So to my mind, whether you have an international party being your endorser or a domestic party being your endorser, it's going to be treated likewise.
No, Aazmeen, I think the question specifically said it's an international celebrity for an international brand.
Yeah.
Okay.
But if it is marketed in India.
Hear me out. The contract between the celebrity and the advertiser is an international one, but they have used the same footage or communication to create a different edit for India and run it here. That's why I'm saying that the Indian person who's using that, the Indian company, wing of that company or the franchisee would be held liable. Would the celebrity be held liable in India? That's what I don't know. An international celebrity would be held.
Yeah. So I think Aazmeen is correct. Given the fact, celebrities allowing that film to be also released or broadcasted in Indian geography, so he'll be held responsible and will be liable to comply with the requirements of Consumer Protection Act.
On a lighter note, one of the celebrities, Benedict Cumberbatch, wanted to sue one of the pan masala companies here because he said the brief was wrong.
Pierce Brosnan.
Yeah, okay. I think we've come to an end of the Q&A session as well. I must kind of thank everybody. Thanks a lot. Thanks, Bombay Chamber of Commerce. Thank you, each one of you. Thanks, Aazmeen, Ashwani, Raj. Thanks, Subhash. Thank you very much for.
Our pleasure. My pleasure.
This has been a
Thank you.
very, very privileged kind of a privilege to host and moderate this webinar. Thanks a lot to everybody. Thanks to the audience. Thank you very much for attending.